Is it up on the screen? Let me start.
All right, we are on the record in the case of the Commonwealth versus Brett Hankison, and we are out of the hearing of the jury. One thing I wanted to put on the record was I think when we left the courtroom on Friday, we were not on the record, Mr. Matthews, when you said that Mr. Hankison had decided to not go on the scene visit. So I just wanted to get that on the record, that that was his decision to not go with us.
Judge, I will confirm that his decision was to not go out to the scene with us.
Okay. Did you all receive my email fairly late last evening regarding the deposition?
Yes.
All right. Anything further on that?
Judge, from our standpoint, we are going to object to use of any portion of the deposition at this point.
Oh, I thought you wanted it all in.
Well, upon reflection and reconsideration, I've decided, it was a deposition that was taken in a civil matter where Myles Cosgrove was deposed by an attorney representing plaintiffs in the civil action. There was no opportunity. Brett Hankison was there by video, but there was no opportunity for him to actually participate in the examination. I don't think that it meets the criteria to be admissible in a criminal case. I think it was not before a judicial officer. It's full of information that we can't cross-examine on, and I just think it's objectionable.
Do you have anything that you can cite to me as far as not using this deposition, that it doesn't meet the criteria? Have you had a chance to look at that yet?
I have a couple things, Judge. Dealing with unavailable witnesses, I would cite the court to Barber versus Page, which is at 390 U.S. 719. It's a 1968 U.S. Supreme Court case. There's language in there that indicates that the witness in that case was a deposition, but my understanding is that a prior deposition in a criminal case may be used if the deposition was taken as part of that criminal case and the witness is no longer available. This is trying to compare apples to oranges. This is not a criminal case that Myles Cosgrove was deposed in. And the case that I just cited was a deposition presided over by a judicial officer with a witness on a witness stand, so that the court felt that even if it was played as the deposition to the jury, they at least had the opportunity to observe the witness's demeanor with the judge presiding. It was like a formal court proceeding. This proceeding with Myles Cosgrove was simply lawyers in an office questioning him, primarily the plaintiff's attorney, and I believe that a vast amount of what was asked there should have been cross-examinable, as opposed to just letting us read portions of the transcript to the jury. So there is another case, Judge, that I would cite, Parson v. Commonwealth, which is found at 144 Southwest 3rd, 775. And that case there, deals with, that's the case, I believe, that deals specifically with discussing the fact that a judge presided over the testimony at the deposition. What was that other one?
St. Clair v. Commonwealth.
Another case, Judge, St. Clair versus Commonwealth, which is at 140 Southwest 3rd, 510. In that case, where's the language? At the trial or upon any hearing, a part of a deposition so far as otherwise admissible under the rules of evidence may be used if it appears from the witness that the witness is dead, or that the witness is out of the Commonwealth of Kentucky unless it appears that the absence of the witness was procured by the party offering the deposition, or that the witness is unable to attend or testify because of sickness or infirmity, or that the party offering the deposition has been unable to procure the attendance of the witness by subpoena. Again, Judge, I feel that it's not that Myles Cosgrove's deposition in a civil case is not admissible in a criminal case. It's trying to put apples into oranges, and I don't think that's proper under the rules of evidence.
Okay, thank you. Ms. Whaley or Mr. Finke?
Judge, as the court stated, Mr. Matthews, as of Friday, asked for the entire deposition. So we haven't done research
Okay.
on this now.
That's
But
understandable.
we would stand on the original memorandum filed in regard to witness Mattingly. And we did cite the cases, in particular, U.S. versus Vartanian, United States versus Vartanian, which was a Sixth Circuit opinion, 245 F3rd 609, wherein a deposition in a civil case was used in the criminal case when the witness invoked the Fifth Amendment. So we can go back and stand on that, but his lawyer was there, and again, Ohio versus Roberts, United States Supreme Court, 448 U.S. 56, stated it does not have to be the same attorney who represented the defendant at the deposition as in the current criminal trial. His attorneys were there, 2 attorneys were there at this deposition, the deposition of Cosgrove. 2 of Hankison's attorneys were there and did participate, actually, throughout the deposition. The fact that he was not there, he was present by video, I don't know if that means Zoom, that meant Zoom, or how video, how he was present. But we maintain that it is admissible, and we have already almost completed the edits that the court sent last evening.
Really?
Yes, we have. That's Mr. Finke.
It was a long night.
I'm sure it was.
Working late. It's almost complete, the video, the edits of the board directed. We would ask that it be admitted.
So when did you plan to use it? Sometime this morning or sometime today?
Sometime today.
All right, well, let's just hold off for the time being, because obviously the change in position takes me a bit by surprise as well. So,
Judge,
yes.
If I may interrupt, if I may eventually view the video and see how that plays, maybe I would change my position again.
Okay. That's fine, we can do that too.
It'll take Mr. Finke about 20 minutes to finish the edits.
That's fine, that's fine. All right, anything else we need to discuss?
The issue of the unavailable witness in regard to Sergeant Mattingly. Commonwealth does plan to call a witness that's with LAPD in the Office of Personnel that will establish that he retired from the department.
Okay. That's fine.
I'll stipulate that.
Well, the court had asked that we establish, that he was released from hospital, and it's not, that the jury wouldn't think that he had not survived.
assume that wouldn't take more than 5 minutes.
Right. Okay. Do we have them all?
I have all the jurors. We're ready.
Just about. I think we're just about ready. All right, but you're ready to go ahead and proceed, Ms. Whaley, with other witnesses, and we'll get back to this issue of, with Mr. Cosgrove. All right. One other thing, ladies and gentlemen who are observing the trial, both the media and the spectators, you're not allowed to have your cell phone out in the courtroom. So keep it in your briefcase, backpack, your pocket, but you are not allowed to have it out. You're not allowed to be on it or use it in the courtroom. If we see you with it out, you will be told to leave the courtroom. If this becomes a recurring problem, then I'm going to order the sheriffs to take all of your cell phones before you enter the courtroom. There were some issues that arose Friday regarding cell phones, so I'm very serious about this. Please, you take it seriously as well. I'd like all of you to be able to remain and watch this trial without any additional problems regarding cell phones. All right. I think we're ready to bring the jury in.